Now, Thomas Ross KC is asking the Crown to look again at prosecuting David Goodwillie after the footballer took part in a podcast last week with James English, and during that interview claimed he's been denied justice and he would be prepared to turn up to a criminal court. Tommy Ross, who represents the woman making allegations against Goodwillie, says it's a very unusual situation, and he wrote to the Crown to think again this morning. Now, Mr. Goodwillie was found guilty of rape in a civil case, but he was also given a letter of comfort that he wouldn't be prosecuted in a criminal case.
The position, John, is, as everybody knows, in July of 2011, the Crown gave David Goodwillie undertaking an assurance that he would not be prosecuted, something which they don't do very often these days. And the result of that is that if he was to be prosecuted, then he would be in a position to take a technical objection on the basis that the Crown were personally barred from proceeding. But unusually, and it's exceptionally unusual, he did a podcast interview last week in which he made a number of comments regarding the case, which could only be interpreted as an indication by him that he wants to be prosecuted in the criminal court because he wants the opportunity to clear his name. And in the course of that interview, he gave an indication that he would go to the criminal court. He said he would go 100%. He wants to clear his name, that his life's been in limbo because he wasn't prosecuted. And all I've done really is bring that interview to the attention of the Crown and asked them to consider whether there is a basis for prosecuting him, and whether we can infer that if they did prosecute him, it sounds from his interview that he's unlikely to raise any technical objection to the prosecution.
Are you saying that by him effectively saying, I want to be prosecuted, he is nullifying this letter of comfort?
I wouldn't go quite so far as that, John. What I'm saying is, the only reasonable interpretation of what he said in the interview was that he wouldn't take any technical objection. He's not personally barred by that interview, so that's where the doubt lies. But I'm happy for it to be known that I've made this request of Crown Office, and if Mr. Goodwillie, through his lawyers, wants to indicate to the Crown that my interpretation of his comments at the interview were correct, then that's probably information which would be helpful for the Crown at this stage.
What exactly have you asked the Crown to do then?
He wasn't prosecuted the first time. That's the problem. So I've taken it in two parts. I've said that the original decision not to prosecute him, if the decision was taken on the basis that there was insufficient evidence, then my take on that is that would be a wrong decision because there is sufficient evidence in law to prosecute him. So that's the first part of it. The second part, which is the trickier part, is that everybody in Crown Office knows that they could go to all the trouble of preparing an indictment, and if he presses the button and takes the objection on the basis that he was told in July 2011 that he wouldn't be prosecuted, then that's an end of it. So, that's the more difficult hurdle, but I have brought the Crown's attention to the various comments which I say are of relevance in the podcast that he did last week, which seemed to be saying, I wish I had been prosecuted, I wish I could be prosecuted because I'm in limbo, I can't get a team, I've never had the chance to prove my innocence. And, I think the only reasonable inference to take is he wants to get to court and clear all this up because undoubtedly, as he sees it, his life has been affected by the decision not to prosecute.
Has the Crown ever reversed the decision not to prosecute without any new evidence?
Not that I'm aware of. Well, at the moment, they can take a decision not to prosecute, but they don't tell the accused that they've taken that decision because everybody knows that things can change. And, in sexual cases, quite often the thing that changes is that another victim comes forward. Now, I'm not suggesting that's in any way relevant to this. It's just an explanation of why the Crown do not commit themselves usually to a decision never to prosecute. Things were a bit different, of course, back in 2011, and I don't think that was the protocol at that time. So it would be hard to know. I mean, I think probably the answer is they have taken private decisions not to prosecute and then changed them. What's different about this is it was about the most public decision not to prosecute that any of us can remember, because 12 years later we're still talking about it.
Yeah, and given this letter of comfort, I'm just curious about two things. One, your personal involvement in the case, and secondly, how hopeful are you that this would proceed?
Well, my personal involvement, John, was dead simple. There's a woman who feels that she's been dreadfully let down by the justice system in Scotland, not by the people who are in charge of the Crown Prosecution Service at the moment, not by them, but by people who were involved in the original decision back in July 2011. And my remit, along with our solicitor, was simply to consider whether there was any way of tackling that particular problem. And while we've been thinking about it, Mr. Goodwillie has done us the great favour of doing this broadcast interview, which has allowed us to think about comments made by him, which obviously he never had to make. So all I'm really doing is saying this might be a plea by Mr. Goodwillie that he wishes that he could be prosecuted. So have a look at it, and if you agree with me, consider whether there would be merit in serving papers on him, just to see what his response is.
Briefly, how hopeful are you this might happen?
Well, it's hard to say, because I only made the request today. I haven't had any indication. I wouldn't have expected any indication this quickly. And I'm slightly concerned that they might say, well, until we know what his position is, then we're not prepared to take the step. But, you know, I have made the point that if it's perceived as a situation where a citizen has been let down by the prosecution service, and certainly that's the victim's belief, then it might be an incredibly unexpected opportunity to put that particular injustice right. And, you know, Mr. Goodwillie himself in the interview spoke of an injustice. He believes that it's an injustice that he wasn't prosecuted. So, you know, legal technical objections aside, it seems that the obvious solution to what has been a very controversial issue for the last 12 or so years.
Just before you go, I know you're busy. I don't know if you've seen these documents that have been tweeted about the original case. They're on social media, and the police have said they're looking into this. Do we know if these documents were real? Have you seen them?
I've seen the documents. I don't know for certain that they are real, but they would give the appearance of documents which might have been used in the civil case. And it is undoubtedly a very distressing thing for any person who's involved in sensitive litigation to find that the documents are placed on social media. It's not what anybody would expect, and I'm very happy that the police are looking into it.
Now, since we did that interview, the Crown Office and Procurator Fiscal Service told us they've received Mr. Ross Casey's letter, and a spokesperson said, "We understand the decision not to prosecute continues to cause great upset to the complainer. The Solicitor General, on behalf of the law officers, will consider the points raised by the complainer's legal representatives." It's drive time. There'll be more on that on GMS tomorrow morning from 6 a.m. Now, the funeral's taken place